The two patrolmen went quiet when Marcus Reed turned from the coffee counter. He lowered his paper cup and studied the pastry case instead of their reflections in its glass. "The Hollis file disappears before morning," one of them had said. The taller officer wore Nolan Voss's name above his badge. Marcus knew the face from photographs, but Voss had never seen the internal affairs detective assigned to investigate him. In dark jeans and a charcoal Henley, Marcus looked like another black man stopping for coffee before sunrise. His credential was locked inside the unmarked sedan outside, exactly where he had left it before walking into his sister's shop. Voss set a brown evidence envelope beside the napkin dispenser. The serialized label carried the Hollis case number. Its red tamper strip had been sliced and pressed back down crooked. Marcus felt the cold edge of the counter through his palm. The envelope was supposed to contain the only known video supporting Ava Monroe's account of what Voss had done to Darius Hollis. Ava would give a sworn statement in 9 hours. Without that recording, the department could call her mistaken, frightened, or dishonest. The second officer, Aaron Vale, glanced toward Marcus. "You need something?" "Just waiting on my coffee." Behind the register, June Bellamy read her brother's expression. She had seen it when their father collapsed at Thanksgiving, and when Marcus testified against his first police supervisor. Not fear, but the effort required to keep fear from becoming visible. Voss and Vale carried their drinks toward the door. Marcus could have called Captain Celia Hart. Instead, he opened his camera beneath the counter. He believed silence gave him control. If Voss learned the Hollis inquiry was active, Ava could disappear before Hart secured her. Marcus photographed the seal. Then Voss pushed through the door, leaving the envelope behind. "June," Marcus said softly, "call 911 and keep the line open." He wrapped a clean napkin around his fingers and lifted the envelope away from spilled coffee. June reached beneath the counter for her phone. The door struck its stop hard enough to rattle the windows. Voss crossed the shop in 4 strides. "Put that down." Marcus laid the envelope flat. "Don't touch the seal. Call your watch commander and an evidence technician." Voss grabbed Marcus's phone. "Were you photographing police property? You don't have permission to search that." Vale moved between June and the counter. Voss looked Marcus up and down, his attention settling on the napkin around Marcus's hand. "Guy watches us leave, then steals evidence," Voss said. "That's what happened. The envelope was open before I touched it. Hands behind your back." Marcus kept them visible. "My identification is outside. Call Captain Hart at professional standards." The title made Voss hesitate for less than a second. Then he drove Marcus into the counter. Marcus's lower lip split against the metal rim. When he tried to turn enough to breathe, Voss hooked a knee behind his leg and forced him down, planting his weight against Marcus's right side. Pain flashed beneath Marcus's ribs. June's open 911 line rested inside her apron pocket. Vale pulled the envelope toward himself with bare fingers. Voss cuffed Marcus, took his car keys, and ordered Vale to search the sedan. "Book him for theft of police evidence and obstruction," Voss said. As Marcus was dragged toward the patrol car, he saw Vale press the broken seal flat with his thumb. The rear door shut before Marcus could see whether Vale opened the envelope again. Through the partition, Voss told dispatch he had arrested a man who had interfered with an active evidence transfer. He did not mention leaving the envelope beside a napkin dispenser. He did not mention the broken seal. Marcus leaned away from the pressure under his right ribs. Blood from his lip had reached his chin, but his hands were cuffed too tightly to wipe it away. He watched June through the coffee shop window. She stood behind the counter with one hand inside her apron, still speaking to the 911 operator. Voss had not noticed. Vale emerged from Marcus's silver sedan, holding the credential wallet between 2 fingers. He opened it beside the patrol car. His face changed first. "Nolan." Voss glanced at the gold shield and the words Internal Affairs Division. For 1 second, Marcus expected the door to open. Instead, Voss took the wallet, studied the photograph, and slipped it into an evidence bag. "Could be stolen," he said loudly enough for June to hear. "We verified downtown." That decision told Marcus more than an apology would have. Voss was no longer acting from ignorance. He was building distance between the arrest and the moment he learned whom he had arrested. The drive to central booking took 11 minutes. Marcus used each turn to reconstruct custody. Voss had carried the envelope into the shop. Vale had touched the seal after Marcus was cuffed. Voss now controlled Marcus's phone, keys, and credential. June controlled the only independent account Marcus knew still existed. He had spent 12 years teaching younger investigators that memory weakened under stress unless they organized it. Location, action, exact language, custodian. He repeated those categories silently while the pain in his side sharpened. He had joined internal affairs after a patrol sergeant ordered him to soften a use of force report during his 3rd year on the job. Marcus had refused and spent the next 18 months working midnight property calls, while officers with less experience moved ahead. June had watched him endure it without asking anyone for help. She had also watched that habit follow him into every room afterward. He had stopped at her shop after an overnight case review because he had promised to repair the loose hinge on her storeroom door before the breakfast crowd arrived. June had inherited the café when their father became too sick to run it. Marcus covered early repairs. She kept a plate warm whenever his investigations erased another meal. Neither of them called the arrangement care. At booking, Voss presented Marcus as John Doe until the desk lieutenant scanned the credential. The lieutenant looked from the screen to Marcus's swollen lip. "Detective Reed? Call Captain Celia Hart through the department directory," Marcus said. "Do not use a number supplied by either arresting officer. Preserve the coffee shop 911 call, the patrol vehicle location record, and every item exactly as it arrived." Voss placed the envelope on the property counter. He contaminated this during a theft attempt. "Then nobody opens it," Marcus said. "Photograph every surface and document every hand that touched it." Vale stared at the floor. The lieutenant ordered a booking nurse to examine Marcus. She found tenderness along his right ribs and recommended transport for imaging. But Voss objected that Marcus was delaying processing. The lieutenant overruled him and requested an ambulance. Marcus expected Hart to arrive before it did. Instead, Sergeant Leonard Keene entered the booking room in full uniform. Keene supervised Voss and had approved the original Hollis force report, the same report Marcus was investigating. Keene looked at the sealed credential bag, then at Marcus. "Professional standards confirmed who he is," the lieutenant said. Keene's expression did not move. "Good. Then add unauthorized interference with a covert evidence transfer and notify the deputy chief. Detective Reed just compromised his own investigation." Keene ordered the desk lieutenant to separate Marcus from the envelope before the ambulance arrived. Then he stood beside Voss while the officer began dictating his probable cause statement. "Unknown black male, observed monitoring uniformed personnel," Voss said. "Subject waited until officers exited, took custody of sealed evidence, and refused lawful commands." Marcus listened from the medical bench. Voss was converting each true fragment into a false whole. Marcus had watched them. He had lifted the envelope. He had refused access to his phone. His silence about his identity now gave Voss's story just enough structure to survive its first reading. "Include the attempt to conceal what was on his phone," Keene said. "I never attempted to conceal it," Marcus replied. Keene did not look at him. "The arresting officer is completing his statement. You'll have your opportunity." Vale signed a separate account claiming he had seen Marcus holding the envelope but had not observed the first physical contact. It was carefully narrower than Voss's version. Marcus recognized the strategy. Vale was supporting the arrest without committing himself to the broken seal. June's preliminary statement was reduced to 2 sentences, describing her as the suspect's sister and an emotionally involved witness. Nothing in the summary mentioned that she had watched Voss carry the envelope inside or that he had seized Marcus's phone before giving an arrest command. The paramedics transported Marcus to Marston General with one officer riding beside him. Imaging confirmed a hairline fracture in his lower right rib. A physician cleaned his split lip, prescribed pain medication, and warned him that shallow breathing could cause complications. The hospital officer remained outside the curtain as if Marcus might flee in socks and a paper gown. Captain Celia Hart arrived carrying neither sympathy nor anger where anyone could see it. She was a compact black woman, with silver beginning at her temples and 26 years in the department. She verified the officer's name, asked the physician to document every injury, and waited until they were alone. "Tell me why you did not call." Marcus described the conversation, the sliced seal, and Vale's thumb pressing it closed. Hart listened, without interrupting. "I needed to know where they would take it," he said. "If I exposed the inquiry, we lost the witness. Instead, you touched the central evidence, let the subject seize your phone, and gave Keene an argument that you ran an unauthorized surveillance operation. I preserved the envelope. You preserved it inside their custody." The distinction landed harder than the pain beneath his ribs. Hart opened a thin folder. Nolan Voss had been selected for the department's new K-9 unit, a position that brought overtime, specialty pay, and a path to sergeant. One more sustained excessive force complaint would remove him from consideration and likely trigger termination proceedings. The Hollis video could provide that final complaint. Keene had more at risk. He had approved Voss's statement that Darius Hollis reached toward his waistband before Voss struck him. If the recording showed Hollis already handcuffed, Keene's review would look less like negligence and more like deliberate protection. Keene was also one of 3 candidates for precinct commander. "That is motive," Marcus said. "Not proof." "Correct. And our proof is now sitting under a contested chain of custody." Hart showed him the transfer authorization transmitted to booking. It directed Voss and Vale to move the Hollis envelope from the district drop safe to the central evidence annex because of an alleged security system outage. Keene had approved the manual override shortly before the café encounter. On paper, the 2 officers had lawful custody. Voss was a named subject, Marcus said. He could not transport that evidence. The transport sheet identifies the case by property number, not by complainant. Keene will claim he never connected the numbers. Hart placed Marcus on administrative leave pending an outside review. She ordered him not to access departmental systems or contact witnesses. The prosecutor would decide whether Voss's theft and obstruction allegations supported charges. Marcus dressed slowly, unable to bend without bracing the wall. When Hart returned his empty wallet, his phone and keys remained booked as evidence. "June's 911 call," he asked. "Preservation request sent. We do not have the recording yet." Hart's own phone vibrated. She read the message twice. A protection officer had arrived to take Ava Monroe to her scheduled statement. Her motel room was empty, and the emergency address had been known to only 4 people inside the department. Hart ordered the protection officer to search only the motel's public areas until an independent supervisor arrived. Uniforms sweeping the rooms would only confirm Ava's fear. Marcus sat on the edge of the hospital bed, one arm pressed against his ribs. She had a check-in procedure. "You are on leave," Hart said. "Do not tell me the procedure. Do not call her. Celia. If she answers you now, Keene will argue you coached the witness after contaminating her evidence." Marcus understood the rule. He hated that Keene understood it too. June collected him from the hospital and drove him to their father's empty house. His apartment had stairs, and she did not trust him to follow the physician's instructions alone. Every pothole forced a shallow breath through his teeth. "You could have said who you were," she said. "They would have known the investigation was active. They found out anyway." Marcus looked through the passenger window. "I thought I could keep you outside it." June tightened both hands around the steering wheel. "You gave me one instruction while a cop put his knee into you. That is not keeping me outside anything." At the house, she placed his medication beside a glass of water and made him practice the deep breaths the physician had prescribed. Marcus lasted through 4 before pain stopped him. His phone was still in police custody. His access card had been disabled. Hart's leave order prohibited him from opening case files, speaking with Ava, or entering any department building except for a scheduled interview. By noon, the police union had issued a statement. It claimed 2 patrol officers had interrupted an unauthorized operation by an internal affairs detective who refused to identify himself and mishandled protected evidence. A local news site published Marcus's Academy photograph above the words IA Detective Under Investigation. The article did not name Darius Hollis. It did not mention the broken seal. It described June only as a relative who had interfered at the scene. Marcus closed the borrowed laptop. Keene had built a defense with 3 layers. Voss had lawful custody under the transport sheet. Marcus had physically handled the envelope. Internal Affairs could not publicly explain why the evidence mattered without exposing Ava and the underlying investigation. June set a legal pad in front of him. You taught me what to record. Location, actions, exact words, and who touched what. Write yours down. My statement has to go through the outside investigator. This is not your official statement. This is what you remember before 6 lawyers tell you what you remember. Marcus wrote, with his elbow held away from his ribs. He recorded where Voss placed the envelope, the slice strip, Vale's question, and every word before the arrest. At the moment Voss found his credential, he stopped. He had believed secrecy was the same thing as control. Now Voss controlled his phone. Keene controlled the transport explanation, and someone inside the department knew Ava's emergency address. Marcus slid the pad toward June. Photograph every page with your phone. Send 1 copy to your attorney and seal the original. It was the first time he had placed part of an investigation into someone else's hands by choice. Hart called from a recorded department line late that afternoon. She had obtained June's 911 audio and transferred it directly to the city inspector general. The call began before Voss contacted dispatch. In the background, Marcus could be heard asking for an evidence technician while Voss accused him of stealing the envelope. It contradicts the sequence in his report, Hart said. It does not prove who opened the seal. What about the envelope? Keene tried to move it from booking to the central annex under his original authorization. The desk lieutenant refused and logged the request. It is now in a restricted locker pending a warrant. Marcus asked about Ava. Hart was silent long enough to answer before she spoke. Ava had used her check-in procedure. She left a coded message with a victim's advocate after receiving a call from a blocked number. The caller had recited her motel room and warned that Internal Affairs could not protect her. She was safe, but she would not reveal her location or give the scheduled statement. Marcus pressed his palm to his injured side. His decision at the café had not created the leak, but it had announced that the investigation was in danger. Ava had paid for the warning. Transfer my entire file, he said. Give the inspector general every version, including my mistakes. No private briefings, no verbal summaries. That removes you from the case completely. It removes Keene's argument that I am controlling it. Hart exhaled. There is one more thing. The district evidence technician found the intake photograph from when Ava surrendered the card. The image had been created automatically at 1:12 that morning. The red tamper strip was straight, unbroken, and sealed beneath the technician's initials. The intake photograph did not return Marcus to the investigation. It changed who had to explain the broken seal. The city inspector general assigned a team with no reporting line to Internal Affairs or Keene's precinct. The next morning, 2 investigators interviewed Marcus at his father's dining table while June waited in the kitchen. A recorder sat between them. Marcus answered every question, including the ones that made him look reckless. Why was your credential in the car? One investigator asked. I had finished an overnight document review and stopped to repair my sister's storeroom hinge. I did not expect police contact. Why didn't you identify yourself verbally? I gave Captain Hart's name and requested verification. I believe disclosing Internal Affairs would warn the officers that Hollis was an active case. Do you still believe that was the correct decision? Marcus looked toward the doorway, where June stood beyond view. No. I treated control as if it were protection. It cost us both. The admission entered the record with everything else. The team separately obtained the sealed case opening order from the department's legal vault. It showed that Marcus had been assigned to the Hollis investigation 6 days before the café arrest. Access history confirmed that the document had not been edited afterward. His authorization covered witness protection, evidence preservation, and covert interviews, though it did not permit him to conduct a solo physical seizure. That distinction mattered. Marcus had not invented an investigation to excuse touching the envelope. He had still exceeded the safest limits of his assignment. Under a court-authorized examination, a state laboratory photographed the envelope before opening it. The dashcam card listed on the property label was gone. The cut ran cleanly beneath the red strip, and microscopic fibers showed the strip had been lifted and pressed down before the napkin fibers from Marcus's hand reached the outer paper. A partial fingerprint inside the adhesive edge matched Voss. The finding reached the prosecutor reviewing Marcus's arrest. She declined to file theft or obstruction charges, noting that the 911 audio captured Marcus requesting preservation before Voss announced an arrest and that no evidence showed Marcus had opened the envelope or possessed the missing card. June read the decision twice. "So you're cleared." Her relief lasted only until another supplier canceled the cafe's standing delivery, saying he did not want trouble with the police association. June had kept the shop closed since the arrest. A photograph online showed tape across its entrance, making it look like a crime scene instead of the business their father had spent 30 years building. Criminally, on these allegations, Marcus shifted carefully against the chair. The administrative review is still open. The Hollis card is still missing. Ava is still hiding. And Voss's fingerprint is inside the seal. He transported the envelope. His lawyer will say he inspected damage Marcus caused and touched the adhesive while securing it. The union made that argument before sunset. Its attorney called the laboratory result inconclusive and said Voss had acted to protect compromised evidence from an unidentified man who refused to show credentials. The statement quietly abandoned the earlier claim that the seal had remained intact until booking. That change was useful, but it was not a confession. Captain Hart visited after completing a formal transfer of the Hollis file. She brought no department documents, only questions the Inspector General had authorized her to ask. "The union statement refers to a planned South Annex transfer," she said. "There was no South Annex on Keene's authorization." Marcus asked June to bring the sealed legal pad. Before the cafe encounter, he had suspected someone was leaking witness logistics. He had prepared 4 preservation notices with identical protective instructions, but different non-essential transfer locations. Captain Hart's copy named Central Property. The deputy chiefs named North Garage. The evidence managers named West Intake. Keene's copy named South Annex. "You built a canary," Hart said. "A limited information test. It could identify where a leak started, not who forwarded it. Why wasn't this in the file you transferred?" "It was stored as an appendix in the sealed case opening order. I didn't want the variations visible in the working folder." Hart called the Inspector General from June's kitchen and disclosed the matrix on the recorded line. Within an hour, the team served preservation demands for the document system, Keene's department account, and the union's communications. Marcus did not make the calls or direct the search. He sat with June while someone else carried the evidence forward. Near midnight, Hart received confirmation that Keene's version had been opened twice, once from his precinct terminal and again from a property room workstation shortly before he authorized Voss and Vale to transport the Hollis envelope. The property room workstation did not prove that Keene had opened the South Annex notice. It proved that his account had. Keene told the Inspector General that he had left his security token in a locked supervisor vehicle while an evidence clerk prepared the transfer. He suggested the clerk might have used it with his verbal permission. The explanation created doubt, but it also created a policy violation. Department tokens were assigned to one user, required a personal code, and could not lawfully be delegated. The access audit supplied the next layer. Keene's badge had opened the property entrance 3 minutes before his account accessed Marcus's notice. His personal code authorized the session. 7 minutes later, the same account generated the manual courier override assigning Voss and Vale to the Hollis envelope. Keene could claim someone followed him through the door. He could not explain how that person knew his code without admitting he had shared it. The Inspector General placed Keene, Voss, and Vale on paid administrative leave. Their weapons and department devices were collected under supervision, but their homes and private property remained beyond reach without warrants. The missing card could not be searched for merely because the three men looked guilty. Marcus received those facts through his attorney, not through Hart. His own administrative interview remained open, and every boundary mattered. June reopened the cafe 4 days after the arrest. Half the morning tables stayed empty. Someone had taped a photocopy of the union statement to the door, but she removed it without reading it twice. Marcus repaired the storeroom hinge in short movements, stopping whenever his rib tightened. "You are terrible at being on leave," she said. "This is not police work. You labeled the screws by removal order." He almost smiled. Then June placed her original phone on the counter. The Inspector General had asked her to surrender it for an authenticated copy of the 911 call history. She had agreed only after her attorney received a written inventory and confirmation that investigators would not search unrelated messages. "I learned that from you," she said. "Trust with conditions." Marcus had always treated trust as a door that was either locked or open. June was showing him it could have hinges. Her authenticated call record confirmed that she contacted 911 before Marcus lifted the envelope. The recording itself captured Voss returning, taking Marcus's phone and accusing him of theft before any dispatch notification of a crime. It could not show the seal, but it fixed the order of events outside police control. The same clean team contacted Ava through the victim's advocate. Ava still refused to meet a police officer. She agreed to speak with a civilian prosecutor and authorized records from the company that manufactured her bakery van's dashcam. The system had not stored her video in the cloud. It had stored a device health index containing the card's serial number, clip length, creation time, and cryptographic hash. Those records showed that the missing card held a continuous clip from the Hollis stop when Ava surrendered it. They could later authenticate the original file if the card was recovered, but they could not reveal what the recording showed. That limitation kept the search focused. Investigators still needed the physical card. The failure that allowed it to disappear was simpler than a sophisticated hack. Property labels displayed only a numeric case code. The transport program did not compare that number with officers named in confidential internal affairs files. A supervisor could also bypass the normal two-person courier assignment during a declared system outage. Keene had declared an outage that network records showed never occurred. The union responded by filing for an emergency order to separate all administrative records from any criminal investigation. Its attorney argued that access logs, interviews, and device returns collected under employment authority could be protected from criminal use. The filing threatened months of delay and warned employees that cooperating outside union counsel might violate their rights. Vail stopped answering Inspector General questions. Voss issued a written denial. Keene called the access history a technical misunderstanding. Then the clean team obtained historical location data from the patrol vehicle through a warrant based on the 911 sequence and false outage. After leaving the cafe, Voss and Vail's cruiser had not driven directly to booking. It entered the secured lower level of the municipal garage and remained there for 8 minutes. Keene's supervisor vehicle entered through a different gate 90 seconds later. The gate system recorded vehicles and access badges, not the people who stepped out once inside, but the lower level contained patrol storage cages, including the locker assigned to Voss. The location history could not prove that the missing card entered that locker. It gave the prosecutor a place to ask a judge for permission to look. The warrant application could not rely on suspicion alone, so the clean team rebuilt every step without using Marcus's compelled administrative interview. The prosecutor used June's civilian 911 record, the laboratory's seal examination, the patrol vehicle data obtained by warrant, and the property audit preserved before any officer was questioned. The judge authorized a search of Voss's assigned locker and storage cage. Execution was delayed for 48 hours while the union challenged whether the city could open department property containing an officer's personal belongings. During that delay, the Inspector General asked Marcus one narrow question through his attorney. "Have you seen Keene use this outage code before?" Marcus studied the code printed on the authorized summary. He remembered it because the digits corresponded to no actual facility alarm. 2 force complaints last year. Both involved evidence transferred after midnight. He supplied no names and opened no system. The clean team retrieved the files independently. The first case involved a delivery driver who accused Voss of striking him during a search. A gas station recording had been logged at a district drop safe, then arrived at central property unreadable. The second involved a woman whose apartment hallway camera showed the beginning of a forced entry. That file reached the annex with 6 minutes missing. Both transfers had been approved by Keene under the same non-existent outage code. Both had used officers from Keene's own shift as couriers. Neither record proved who damaged the files. Together, they showed that the Hollis transfer was not an accidental workaround invented during one busy night. The promotion system had helped the pattern survive. Complaints closed for insufficient evidence did not count against specialty assignments or command applications. Voss remained eligible for the K-9 unit because the earlier cases had closed without sustained findings. Keene's precinct commander score benefited from a low rate of sustained force complaints. No written policy ordered anyone to destroy evidence. A weak transport program, promotion incentives, and Keene's override authority created the opportunity. Voss and Keene had chosen how to use it. The Inspector General referred the 2 older cases for independent review. The department announced a temporary 2-supervisor rule for evidence transfers, but the union called the change an admission that the prior system had been too unreliable to support criminal accusations. Marcus read that argument at June's counter, while the cafe's first normal breakfast crowd in a week moved around him. His ribs still prevented him from lifting supply boxes. June refused his help and made him work the register instead. Darius Hollis appeared on the muted television above the pastry case. He stood outside his attorney's office with one hand still braced from the traffic stop. Captions reported that prosecutors had reopened the investigation into his arrest. They finally used his name, June said. Marcus watched Darius step away from the microphones without answering questions. Until then, the public story had treated him as a case number and Marcus as a corrupt detective. The correction was incomplete, but at least the original harm was visible again. The union's preservation records produced another connection. 6 minutes after Keene's account opened the South Annex notice, his department phone called the union liaison. The call content was unavailable. 2 hours later, a draft union memo used the phrase South Annex transfer. Keene claimed he had discussed scheduling and that someone else must have supplied the phrase. The clean team still lacked proof of what passed between the 3 men in the municipal garage. The gate logs established arrival. They did not establish a handoff. The access audit established opportunity. It did not reveal where the card went. That missing link became more important when Vail requested immunity through his attorney. The prosecutor refused full immunity but offered to consider a limited agreement if Vail provided independently verifiable information. Vail withdrew the request and remained silent. The union lost its challenge to the physical locker search. State investigators entered the municipal garage with a court clerk's inventory officer and a forensic technician. Voss's locker contained uniforms, personal mail, training gear, and 3 found property pouches that had never been entered into the property database. 2 held cash and keys from unrelated stops. The third was labeled unclaimed keys but felt almost empty. The technician photographed it, cut the pouch along a new edge, and found a micro SD card taped beneath the paper label. The serial number matched the card listed on Ava's evidence envelope. Before anyone viewed it, the technician created a forensic image and compared the file hash with the dashcam company's independent device health record. The values matched. The missing Hollis video had been recovered from Voss's locker. Within an hour, the union filed to suppress it. The motion argued that the warrant was tainted by administrative access logs and by Marcus's compelled disclosures, turning the recovered card into evidence that might be true, decisive, and legally unusable. The suppression motion forced the prosecutor to prove 2 cases at once. One concerned what Voss had done. The other concerned how the state had learned where to look. Voss's attorney argued that Marcus's internal affairs interview had infected the entire investigation. Keen's attorney claimed the property logs were employment records gathered under threat of discipline. Both insisted that the clean team existed only because Marcus had conducted an unauthorized operation at the café. The prosecutor responded with an independent source timeline. June's 911 call was created by a civilian before Marcus was arrested. The envelope photograph had been generated automatically when Ava surrendered the card. The seal examination came through a judicial warrant. The vehicle location order relied on the 911 sequence, the false outage, and records created before any compelled interview. The court scheduled an open evidentiary hearing 3 weeks later. Until then, the video remained sealed. Marcus was not permitted to view it. He learned only that its hash matched the manufacturer's index and that the clip played without corruption from beginning to end. The union changed its public defense. It no longer claimed the card had never existed. It suggested someone had planted it in Voss's locker after the café arrest. Supervisors possessed emergency access to patrol storage, and the pouch had not been registered in the property system. Keen accused the Inspector General of constructing a case around ambiguous technology and a disgruntled detective. The locker audit narrowed that claim without eliminating it. Voss's badge opened his storage cage after the cruiser entered the garage. Keen's master credential opened the surrounding patrol area 90 seconds later. No credential opened Voss's cage again before state investigators executed the warrant, but the electronic record could not prove what either man carried inside. That was the defense's strongest point. The state could establish exclusive opportunity between Voss and Keen. It could not place the card in a specific hand during those 8 minutes. The pressure reached Marcus through a different door. Department counsel offered to resolve his administrative case with a written reprimand and immediate reinstatement if he acknowledged poor judgment and agreed not to discuss confidential evidence procedures publicly. The agreement would restore his salary status and remove the suspension from any promotion review. His attorney read the final clause twice. If you sign, they can argue you are barred from testifying about the transport weaknesses unless subpoenaed. And if I refuse, they can pursue suspension or termination for acting alone, handling the envelope, and withholding identification. Marcus carried the unsigned agreement to June's café. She was preparing financial records demanded by Voss's lawyers, who claimed lost business gave her a motive to exaggerate the arrest. The subpoena sought supplier messages, bank deposits, and private texts between her and Marcus. You can sign it, June said after reading the offer. You made a mistake. Taking discipline is not surrender. The confidentiality clause protects the same gap Keen used. Then reject that clause, not your own mistake. Marcus had entered internal affairs, believing perfect control made him credible. Now his credibility depended on allowing a court to see where he had failed and where the evidence did not depend on him. He rejected the agreement and offered voluntary testimony subject to full cross-examination. The department extended his leave without promising pay beyond the next review period. June closed the café for a day to sit through deposition. Voss's attorney asked whether she hated police, whether Marcus had coached her, and whether she expected money from a lawsuit. June answered each question in the same measured voice she had used with the 911 operator. My brother told me to preserve what happened, she said. He did not tell Officer Voss what to say while the line was open. Ava gave a separate protected deposition to the civilian prosecutor. She identified the card's serial number from the receipt she had received when surrendering it. The dashcam company's custodian authenticated the matching index and hash. Neither witness had contact with Marcus after the café encounter. The defense then requested the original dashcam device, knowing Ava's bakery employer had returned the leased van months earlier. The prosecutor produced the manufacturer's maintenance record showing the same device identifier and card serial. The missing van could not erase the record created when the clip was made. On the morning of the hearing, Marcus wore a dark suit, loose enough not to press against his healing rib. Hart sat behind the prosecutor but did not approach him. June took a seat beside Darius Hollis, whose braced hand rested on the rail between them. Voss entered with his attorneys. Keen sat at a separate table, no longer willing to share a defense. Marcus was called first because the defense claimed every later step began with him. Under oath, he admitted touching the envelope, failing to call Hart, and withholding his identity while trying to preserve a covert case. Voss's attorney approached the lectern. So this court is expected to trust a chain of custody that you personally compromised? No, Marcus said. The court should trust only the parts that can be established without me. The prosecutor rose and placed the independent source timeline on the courtroom screen. The prosecutor's timeline began before Marcus entered the café. The first image showed Ava's envelope at district intake. Its strip was intact, its serial number readable, and the technician's initials sealed beneath the adhesive. The next entry showed Keen's badge opening the property room. His token accessed the South Annex notice, and his personal code approved the false outage and courier override. Voss's attorney objected that those records came from an internal employment system. The prosecutor called the system custodian, who explained that the logs were created automatically during ordinary use. No investigator had compelled Keen to generate them, and their preservation occurred before his administrative interview. The judge admitted them for the limited purpose of deciding whether the warrant had an independent basis. June's 911 call came next. Her voice was low as she gave the café address. In the background, Marcus told Voss not to touch the broken seal and asked for an evidence technician. Voss accused him of taking police property. Only afterward did Voss notify dispatch that a theft had occurred. There was no dramatic confession on the recording. Its power came from sequence. Voss's written report said he had announced the arrest before Marcus resisted and before taking the phone. The call established the reverse. Voss's attorney emphasized that the audio could not show who opened the envelope. That is correct, Marcus said when recalled. It establishes what it records and nothing more. The answer denied the defense an exaggeration to attack. The prosecutor moved to the laboratory findings. The intact intake photograph and the fiber layers placed the cut before Marcus's napkin touched the paper. Voss's print inside the adhesive did not establish when he removed the card, but it contradicted his original claim that he had never opened or inspected the seal. Keen's attorney attacked Marcus's version notices as an unauthorized trap. Marcus explained that each notice carried identical safety instructions. Only a non-essential transfer label differed. No operation or employee had been placed at risk. And the phrase South Annex appeared where? The prosecutor asked. Only in the version available through Sergeant Keen's account. The document custodian confirmed that Keen's credentials opened that version shortly before his phone contacted the union liaison. The union draft later repeated the unique phrase. The call's content remained unknown, and Marcus said so. The records proved a path for the leak, not the words spoken during the call. The courtroom then turned to the garage. Vehicle and gate records placed both police vehicles inside. Voss's badge opened his storage cage. The cage remained electronically closed until the warrant team arrived. Supervisory emergency access required breaking a numbered mechanical seal, and the inventory officer testified that the seal remained intact when state investigators entered. The forensic technician described photographing each pouch, opening the one labeled unclaimed keys along a fresh edge, and finding the card beneath its label. She created a forensic image before viewing any content. The serial matched Ava's receipt. The cryptographic hash matched the dashcam company's record created when the clip was recorded. Voss's attorney stood. A matching hash proves this is the same file. It does not prove my client placed it there. Agreed, the prosecutor said. Possession and intent are questions for the criminal case. Today's question is whether the card was found through a lawful independent search. The judge reviewed the warrant without Marcus's administrative interview. June's call, the intact intake photograph, the false outage, the vehicle location, and the locker access record remained. Together they still established probable cause. The court denied the suppression motion. The judge warned that the ruling did not determine guilt. It meant the state could use the recovered card and independently obtained records in later proceedings. Marcus's compelled statements remained outside the criminal case. For the first time, the Hollis video was played in open court. The bakery van's dashcam faced the curb across from the stop. Darius stood beside his car with his hands cuffed behind him. Voss searched his waistband, found nothing, then shoved him against the hood. Darius turned his head to speak. Voss struck him across the face and drove him to the pavement while Vale stood at the rear quarter panel. At no point did Darius's cuffed hands move toward his waistband. The clip did not show Keene ordering the assault. It did not show the café or the garage. It proved exactly what Ava had reported and exactly what Voss's force statement denied. Darius watched without moving until his injured hand began trembling against the rail. June placed her palm beside it, close enough to offer support without touching him. Marcus kept his eyes on the screen. The video restored Darius to the center of a case that had nearly buried him beneath everyone else's arguments. After court, reporters called the ruling an exoneration for Marcus. He corrected them once. The charges against me were declined. Today's ruling preserves evidence in Mr. Hollis's case. Accountability still requires due process. That afternoon, the independent prosecutor filed notice that the video, access records, seal findings, and vehicle history would be presented to a grand jury. Voss and Keene remained suspended. Vale's attorney renewed his request for a limited cooperation agreement, but no promise had yet been made. The evidence had survived. Judgment had not yet arrived. 6 weeks after the hearing, a grand jury indicted Nolan Voss for evidence tampering, obstruction, filing a false report, and assault under color of authority. Aaron Vale accepted a limited plea to obstruction and false reporting. His statement confirmed that Keene ordered the unscheduled garage stop, but prosecutors used it only after the vehicle, gate, and access records had independently established the meeting. Vale admitted seeing Voss enter the storage cage with the envelope pouch. He claimed he did not know the card had been hidden beneath the label. The court required him to testify truthfully, surrender his certification, and serve probation after a short jail term. His cooperation reduced his punishment. It did not erase his decision to sign a false report while Marcus sat bleeding at booking. Keene was indicted separately for obstruction, evidence tampering, and misuse of official access. He denied directing the removal of the card and blamed Voss for acting beyond the transport order. His criminal case remained pending after repeated litigation over which administrative records could be used. The Civil Service Board did not wait for a criminal verdict. After a 4-month hearing, it upheld his termination for the false outage, unauthorized credential sharing, and failure to disclose conflicts. The State Certification Commission began its own decertification proceeding. Marcus's administrative case ended sooner. The review rejected every claim that he stole evidence, fabricated the Hollis inquiry, or coached June. It also found that he had violated safety policy by acting alone, physically handling the envelope, and delaying clear identification after Voss confronted him. Marcus accepted a 10-day suspension without pay. He refused language describing his actions as dishonest and insisted that the written decision include both his mistake and the officer's conduct. The department restored him to duty without a confidentiality agreement. His first week back, he did not return to the Hollis investigation. That case belonged to the independent prosecutor, and Marcus no longer confused ownership with responsibility. Hart assigned him to review evidence transfer safeguards with civilian auditors, property technicians, prosecutors, and patrol representatives who had opposed Keene's methods before anyone listened. Hart underwent a separate review for transferring the file outside her division. Investigators concluded that she had followed the Inspector General's conflict protocol and preserved records that Keene attempted to move. She remained in command, but she ended the informal practice of letting one trusted detective carry a sensitive case alone. Marcus supported the change even when it reduced his own discretion. The city replaced numeric-only transport labels with conflict alerts that blocked officers named in protected investigations from serving as couriers. After-hours overrides required 2 supervisors from separate commands. An external audit sampled every manual transfer each month. The changes could not guarantee honest choices, but they removed the quiet shortcuts Keene had repeatedly exploited. Darius Hollis's original charges were formally dismissed with prejudice. The department corrected his arrest record and acknowledged that its force report had falsely described his hands as free. After mediation, the city settled his civil claim for medical care, lost wages, legal fees, and additional damages without requiring secrecy. Darius used part of the money to reopen the repair bay he had lost while recovering from his injured hand. Ava testified at Voss's trial under a protective order. Defense counsel challenged the angle, distance, and reliability of her dashcam, but the authenticated clip showed Darius's cuffed hands continuously. Ava returned to her delivery route after the court prohibited disclosure of her home address. She never called Marcus, and he never asked her to. Respecting that boundary became part of protecting her. 9 months after the café arrest, a jury convicted Voss on the evidence tampering, false report, obstruction, and assault counts. The judge imposed a state prison term measured in years rather than decades and prohibited him from holding law enforcement employment. The Certification Commission revoked his license after a separate hearing. Voss appealed. No one pretended the ruling ended every proceeding. Marcus's rib healed before his reputation did. Some officers continued to say he had set a trap for patrol. Others quietly brought him records they once would have hidden. He responded the same way to both groups. Preserve the original, document access, and never make one person the only custodian of the truth. June's café recovered slowly. The canceled supplier returned only after customers began asking why he had left. June accepted his apology, but renegotiated the contract. She kept the legal pad from the day Marcus came home from the hospital inside a fireproof box, beside the authenticated copy of her 911 call. At their father's next medical appointment, Marcus let June lead the questions, instead of arriving with a private plan already formed. They disagreed about home care, wrote down both options, and decided together. For Marcus, sharing responsibility remained harder than assuming it, but he stopped treating difficulty as danger. On the anniversary of the arrest, Marcus finally replaced the bent metal rim where Voss had split his lip. June watched him measure it twice. "Still labeling the screws?" she asked. "Some habits are useful. And the others?" Marcus placed his phone on the counter, instead of turning it face down. He had spent years believing the people he loved were safest when they knew nothing about what frightened him. That belief had left June alone inside a crisis he had tried to control. He told her that Keene's trial might require him to testify again. He told her he was worried about their father's next medical appointment and about returning to rooms where officers knew his face. He did not package the fears as facts or wait until he had solved them. June poured 2 coffees and carried them to the table by the front window. Outside, the morning traffic moved past without sirens or cameras. Inside, Marcus left his phone face up between them and stayed long enough for both coffees to grow cold.